Good morning.
All right, Ms. Fears, you ready? All right, this is case 17-123341, the Michigan Women's Foundation versus Dynasty Fit LLC, and Randy Spencer, also known as AKA Randy Henry. Appearances, please.
Lindsay Ott appearing on behalf of the plaintiff, Michigan Women's Foundation.
Good morning, Your Honor. Charles Hayden on behalf of defendant Randy Henry.
All right, Mr. Hayden, we're here on behalf of your client filing a motion for relief of judgment. I had a chance to review the motions and the briefs,
Yes.
and the response and the supporting briefs. Anything that you want to add?
Yes, Your Honor. I actually did attempt to file a response to Ms. Ott's brief. My chance was it received by the court?
You didn't fax it, did you?
No, Your Honor. Unfortunately, we were told to mail it, so it's been mailed.
How long ago?
I believe Monday, Your Honor.
Yeah, I don't have it yet. It's probably being processed.
Yes, sir.
All right. Did you receive, Ms. I? Did you receive the response?
I did receive the reply brief. My issue is that in order to file a reply brief, they would have had to seek leave from the court, given that this isn't like a motion for summary or something similar to that.
Okay. All right. Well, you can go forward, Mr. Hayden.
Thank you, Your Honor. Your Honor, at the time we filed this motion, we did not have any information regarding attorney fees in writing. We even reached out to opposing counsel for further information regarding any agreements with such attorney fees. However, opposing counsel did not release these agreements until the response to our brief. Notwithstanding their arguments with the security agreement, the guarantee agreement, we still believe that the attorney fees asked are still unreasonable. According to the plaintiff's response brief, Exhibit D, plaintiff claims that the total amount of attorney fees for the totality of this situation is $8,342.25 and counting at a rate of $360 an hour. The Michigan Supreme Court.
The billable rate is $360 an hour, Ms. Ott?
Yes, that's correct. And then Michigan Women's Foundation received.
Collection case?
Yes, Your Honor. And the Michigan Women's Foundation.
Really, Ms. Ott, on a collection case, $350 an hour. Are you serious?
That is our general.
I wanted to ask you what your rate was. That's unreasonable. That's unreasonable. On a collection case where you got a default judgment and you're collecting on the case and she's paid the bulk of the amount, that's what I wanted to see. I wanted to see your billable hours.
Sure, Your Honor. And for the court's convenience, I attached a chart along with the invoices as well, so you can state of why the attorney's fees were necessary. Additionally, Michigan Women's Foundation.
You got the $3,200 with the default judgment and the cost, the initial work, and then she signed a consent agreement, and then after that, Mr. Henry, did she started paying, or was there garnishments?
There was garnishments, Your Honor.
Okay, once you had the garnishment in place, was it a periodic garnishment or non-periodic? Was it from employment checks or what?
Yes, Your Honor, it was a periodic garnishment. The reason that the attorney's fees are higher than probably normal in a default judgment case or a consent judgment case is because this has been a constant battle. First, we issued the garnishment, and then her employer stated that she no longer worked there. And apparently, I don't know if she was reemployed or whatnot, but once we issued garnishee interrogatories, we found out she was employed there. So there were some fees associated with that. Additionally, she then filed an objection to the garnishment, and we filed a response and then had to have a hearing on that. And then after that, which those objections were denied. And then after that, then this motion was filed, which of course we had to file.
Okay, so subsequent to that, you're saying that what you just told me, that your billables amount to like $5,800 for those three things?
I'm sorry, Your Honor, I didn't hear the amount that you stated.
So my understanding is we're talking, And Mr. Henry, I don't think you're contesting that they're entitled to the interest, are you?
Pardon me, Your Honor?
You're not contesting that the plaintiff is entitled to the interest on the judgment, correct?
No, Your Honor. The
All right,
attorney.
so we're just talking basically about the attorney's fees, correct?
Yes, Your Honor.
All right, so those three things that you just mentioned, Ms. Ott, the hearing where we entered a consent agreement and the garnishment, and I think you said you had to send interrogatories out. Those three things amounted to billables that amounted to attorney's fees in the amount of $5,800.
So, Your Honor, for example, the year 2017, which is when we began, issuing a demand letter and things of that nature and trying to work with her to get her to pay, that was $1,400. By the time we got the judgment, there was another $3,300, so roughly $5,000-ish by the end of 2018.
Well, she paid the 32 in the initial judgment, correct?
I'm sorry?
That's paid the 32, the initial 32 before the default judgment has been paid, correct?
Some of that has been paid. The additional amount that has been accrued, which this is as of the end of August 2020,
that's $5,800.
Is $3,500.
Mr. Hayden, is that right?
To my understanding, Your Honor, again, Ms. Ott is asking for actual fees, and from what I understand of what the Michigan Supreme Court ruled when it comes to Smith v. Court is that actual fees are not rewarded unless they've been expressly stated in the contract. In the guarantee contract, it does state that reasonable fees are allowed. In the security agreement, it says all fees. And now we have Ms. Ott asking for actual fees of $3,000. And even so,
here's the problem, Ms. Ott, here's the problem. You drafted that document. Now, how is Ms. Henry supposed to know if you're talking about actual fees or reasonable fees? It's not stated in the agreement. I read it. It's not stated in the consent agreement.
Your Honor, so it states continuing attorney's fees, which we believe are reasonable and would be actual fees.
No, that's a difference. It's a difference. If you're billing at $360, that's your actual fees. And I'm telling you, that's not reasonable. Not in the collection case.
Your Honor, I disagree.
The collection case.
But I would be
not
happy.
A labor case or anything like that. That's an excessive amount of money to be charging and billing on a collection case.
I would be happy to, Your Honor, filing a supplemental brief outlining the law in this area, which I've done in several other cases, which relies on the Michigan bar economics and whatnot, and the court can decide what they feel is a reasonable fee. Michigan Women's Foundation does receive a broad discount of 10% on their invoices as well. But nevertheless, that would be 10% off of my $360. The issue, Your Honor, is that these issues should have been brought up in years ago when the consent judgment was entered. She could have retained counsel at that time. And then again, they were brought up in the objection to garnishment hearing that we've already had. And once again, they were not. In the agreement,
you could have put a liquidated amount in there. And you just put all attorney's fees. At that point, you knew that you had some attorney's fees already. You could have put a liquidated amount in there, some certain, to say, okay, well, here's what we have so far, plus any reasonable or actual attorney fees from henceforth. So you didn't do that. So it's a lot of ambiguity in that agreement. I don't know if you want actual fees or if it's a reasonable fees.
Are you referring to the consent judgment itself? So within the consent judgment, the only fees at that time that I could include were the ones that I already knew existed, and those were included. And then given that we wouldn't know fees that were going to accrue post-judgment, that's why it states in continuing costs and attorney's fees.
All right, well, I still don't have what your billables are, and I don't know what's reasonable or not, because that sounds like an excessive amount of money on a collection case. And Mr. Hayden is entitled to contest those attorney's fees. If they're excessive.
Your Honor, as I stated before, I don't believe there's a court rule or any law that authorizes him 2 years after a judgment has been entered to now contest the attorney's fees which have accrued.
They believe that the judgment's been satisfied. That's why.
And Your Honor, I included the detailed amount of each and every invoice to state why it has not been satisfied, including my invoice amount from each month, to the extent that the court would prefer that I provide the actual invoices, which are redacted for any attorney-client privilege, which I don't expect a lot of that to be in there. I would be happy to provide those if, in the event he wants to question, for example, that some of the work was unnecessary or whatever else, or wants to see that it actually was done, I would be happy to do that.
All right. Good morning, Mr. Jones. How you doing, sir?
Good morning, Judge.
All right. Okay. Here's what I'm suggesting. That maybe you and Mr. Hayden should do a breakout room to try and work this out. Mr. Hayden, now is your client have to pay any additional attorney's fees, or did you reach out to try and resolve this short of paying the $3,000 or $4,000?
Yes, Your Honor. I did reach out to opposing counsel to see if there was some way that we could resolve this matter prior to filing this motion. However, Ms. Ott came back to me and told me that $5,000 were owed and counting. And after reviewing the judgment and seeing charges such as traveling and parking to Detroit, attention to receipt of funds, attention to garnishments, it was just so egregious that there was no point in which, at the rate it was going, my client would never get up under this judgment.
Yeah, I need to know of whether or not those billables are ministerial actions. I mean, ministerial acts that maybe a clerk could have done or a secretary could have done. I don't know what you're billing, Ms. Ott. They haven't seen it. They have the opportunity. They have the right to contest those attorney's fees. If you're billing at a rate where a law clerk could do the work, which I'm submitting that they could, or an administrative assistant could do that with respect to the garnishments, which I'm submitting that they could, that those fees are unreasonable.
Your Honor, my assistant.
$50 an hour and $5,000 on a collection post judgment?
It has not, Your Honor, been $5,000 post judgment, but nevertheless, I have delegated quite a bit of work to my assistant who does not bill anything, but my client is entitled to reimbursement, for example, for my time and parking for a court hearing. That's clearly a court cost. Additionally, Mr. Hayden obviously has the invoices, given the fact that he's citing from them right now. What was suggested to Ms. Henry at the hearing on the objection to garnishment by this court was for her to work with us to attempt to get on a payment plan, so this doesn't keep happening. But the fact that post judgment, she's been fighting this for years and could have obtained counsel quite some time ago, is disturbing. And I feel that that's why we have 2.612 and why we have the limitations in there in order to avoid this. And most of those fees could have been avoided.
Hayden.
Your Honor, at this point, I would like to request a breakout room so that we can talk to Ms. Ott and see if we can resolve this in a reasonable manner, because she's claiming that my client should have known about this, or I should have retained counsel at the time. But even a reasonable person looking at this consent judgment would not expect that they would be charged $360 an hour for additional fees and counsel.
I'm telling you, hold on, Mr. Hayden. I'm telling you now, Ms. Ott, that's unreasonable. In a collection case in a district court for the amount of money that was the default judgment amount, that's unreasonable. I haven't had $360. I've been on this docket for almost 4 years now. I haven't had an attorney's fee that high ever on a collection case. There's a distinction between a collection case and other types of litigation. That's outrageous. So I'm suggesting to you that you need to meet with Mr. Hayden. I don't know if Mr. Jones wants to participate in that or not, but you need to get in the breakout room, because I'm not going to grant $360 an hour on a collection, a post-judgment, post-consent agreement where you got it somewhere between $3,000 and $4,000 and $5,000.
Your Honor, I understand the court's position, but I will not have any authority today to settle that. I'm certainly willing to speak with my client and then schedule a time maybe in the next week or so for Mr. Hayden and I to have a discussion.
Well,
That's okay, Your Honor.
you want to talk today or and then get back, or you want to just adjourn this?
Mr. Hayden, what's your preference? I need to speak with my client before I feel that any sort of breakout room or discussion is going to be advantageous for us.
As long as I would like to talk today, just so we can have some type of mutual understanding prior to you talking to your client, and this dragging on even further.
I think that sounds fair.
Mr. Jones, you want to participate?
Yeah, I would like to as well.
You want Mr. Smith in there, Ms. Ott?
Yeah, I think that would be helpful.
All right, let me. I think I have all four of you now. Did you get the invitation?
I did not.
I did not either.
No, Your Honor.
Oh, hold on. What about now?
Yes,
Yes.
sir.
Okay. Ms. Fears, how you doing?
I'm great, Your Honor. How are you?
I'm doing all right.
That's great. That's great. Yeah.
Your Honor,
Yes?
this is regarding tomorrow's cases. We have a total of 4 hearings for examinations.
Yeah.
I just received a call from the plaintiff on 2 of those cases. The last 2 cases, the last 2 for 9:30, and they have not been able to serve them. So she wants to know, can we just give her, reschedule those? I have her number to call her back, but I can wait until after we're done, but I just wanted to give you a heads up. So that would just get the 2 9:30 cases.
Okay.
They wasn't able to serve them, so. Okay, I'll talk to you after we're done.
All right. Thank you.
You're welcome.